Hello there, everyone. Thank you for joining us today as you're coming in the webinar room. I want to welcome you. My name is Marche. I'm the webinar director here at Advice Chaser. Before we introduce our guest and get started, I do need to do a little bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars, such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own and however true, funny, or interesting are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. We are thrilled to bring you this educational presentation. Attendees are muted, but we do encourage you to ask questions using the chat box, and we'll go ahead and address those queries during the question and answer period today as appropriate. If you ask a question in the chat box and we're not able to get to it, go ahead and leave your contact information as well, such as your email address and your phone number. If we can't get to your question, or if your question requires some offline care, go ahead and leave that question and we'll reach out to you and make sure that that is addressed. We want this experience to be as educational as possible. So again, please don't hesitate to ask for clarification or expansion of the material. We are happy to help. Well, I'd love to introduce you to our presenter today and welcome you back also, Brenda. Brenda Bridges is a financial advisor, mediator, certified divorce financial analyst, retirement income certified professional, and certified divorce coach. She's also the founder of Bridging Divorce Solutions, which helps couples divorce by implementing a non-adversarial process, one that is not financially confusing and not unreasonably costly. Using alternative dispute resolution instead of or addition to the court system means families can own their decisions and design their lives during and after divorce. Brenda and her team believe in changing the unknowns of divorce to an understandable and streamlined process, morphing fear into hope and questions into confidence. And Brenda, I'm excited to have you back. I will mention that we have had you before. We did another webinar called Women's Guide to Divorce, although I'm sure that the information in there would apply to both genders. And that's available on our website. So I'm going to go ahead and turn over the time to you. And I can't wait to hear what you're going to say. Yep.
Thank you and welcome everybody. I appreciate you taking the time to look for information that can help you as you're going through this process. I know it's a difficult one. What we're addressing today is more of a top line as to how to approach the beginning of the process of divorce. So what you'll learn is a little bit about each process. We actually went into this in more detail in the other webinar that Marche mentioned, so you can find that on their website, as well as thoughts as to how to start putting your team together and what you might consider as you do that. Okay, so there are different types of divorce. Often this is a surprise to people. Litigation, which is the first on this list, is the one that people are most familiar with, if you will. And that model, again, we'll go into a little bit more detail, is a court-based model. That's what we tend to see on television shows and soap operas and whatnot. Collaboration is a team-based approach, and that uses alternative dispute resolution, as does mediation, and then pro se, which is self-representation. We're going to go into a little bit more detail on each one. But the importance of looking at this at the beginning is knowing how to match you, your family, and your situation to the right process. And then you're much more likely to have a successful outcome. And I know it might seem a little funny to talk about a successful divorce, but a divorce that is less expensive, less damaging, more informed, if you have a family more child-centered, is always going to be more successful than one that is, the stereotypical knockdown, drag out, expensive process. So that's what we're here to talk about today. Litigation, the court-based model. If it's right for you, think of litigation as the least communicative, and it's also the most adversarial. Usually, most cases in litigation don't actually go to court. Don't quote me on this exact number, but it's somewhere around 95% settle out of court. But with court as the, if we don't come to an agreement, that's looming overhead. Litigation might be right for you if you really are in a place where you and your spouse cannot communicate, and it's better done through another representative, in this case, your attorney. Litigation can certainly be right for you if there's any kind of abuse, if there is a question of safety, if there is not enough of a level of trust that hiding money is suspected, if there's infidelity, if there's a very big power imbalance in your relationship, then using those professional legal representatives might be the best option for you. What I do coach my clients through as we're looking at the process is, like I said, matching what's best for you. And you can always become more aggressive in the process. But once you start out at the end of the scale in litigation, if you drew a line from least to most aggressive, litigation is going to be the most aggressive of the divorce processes. So if you start out that way and then say, oh, I might want to try mediation, that's really hard to walk back. So that's just something to consider. If you start out with mediation and you find it's not successful, you can always move forward into something that is more court-based. Next process we're going to talk about is collaborative. Now, collaborative isn't as well known as most other processes. Litigation, certainly people know about, get a lawyer, you are served, go to court. Mediation is becoming more and more well-known and a used methodology for becoming divorced. The collaborative process has really strong geographic pockets in our country. So first you would need to know if it's even available to you. If it's not, and in some areas I practice, it isn't under the law available, you can still work with this process as a hybrid that's not a true collaboratively trained organization, or that the professionals aren't, but they're still collaboratively minded. So when does collaborative make sense? When you and your spouse know you're going to get divorced and you want to reach an agreement, you want that agreement to be goals-based rather than winning-based. It's often used with a more complicated situation involving children, finances, assets, long-term marriage, perhaps businesses. It can be used when the couple getting divorced struggle to communicate with each other. And let's face it, if a divorce is happening, there are likely going to be communication issues, but they still want to be thoughtful and mindful about their process. And they have a team of professionals that help walk them through the process to make their decisions. When you're doing this, you really need professionals that are behind the process. As a collaborative divorce professional, there are organizations within the state, and the international organization is the International Association of Collaborative Professionals. So if this is a process that interests you, you can find professionals who are trained in it through that as a resource. Collaborative could be right for you if you have a complicated situation, more complicated. And by that, I mean, there are business asset, financial support, and family decisions that you want to be involved in, but you don't know exactly how to work through them. If you with a team, because in collaborative, you're sitting around the table having the meetings together, what that means is you're eliminating the back and forth with attorneys. So if you picture a litigation process, you have one party talks to their attorney talks to the other attorney, that attorney talks to their client, and the response goes back and forth through that chain. And we think of that old game of telephone. When you're doing that, often things are lost in translation. So you might say something, which by the time it gets to you're going to be ex-spouse, it sounds entirely different to them. When you're in the same room, you can bring clarity to that without having that chain of events. Also, when you're in the same room, you have more control over what is being discussed and how it's being discussed than if you're turning it over to other parties. There are neutrals. So in collaborative, you each have an attorney and they're there to represent your best interest. You also have professionals, a financial neutral, often a divorce coach, maybe two. There could also be a child specialist, depending on your situation. So those professionals are there to bring the information to you in real time. Whereas if you're working through a litigation or even a mediation in some cases, if, say, financial questions come up, you don't have to table them and say, we need to look at, in many cases, some cases you might, so always qualifying things. You don't have to table them. You have a financial professional right there to answer your questions about what the specific ramifications of some of these decisions you're making are in your divorce. Again, about the assets, about budgets, about living expenses, about mortgages, about so many things that are financially, so much of divorce is financial in nature. So when you use this process and have a person who is there to give you the information you need at that time, then you can reach a more sound decision usually. And often you reach that decision more quickly because you have ready information. So summing up, collaborative, if it's available in your area, you can find professionals on the IACP website, or if there is a local collaborative group in your area. And it could be good for you if you want to go through the process of divorce with professional support, but making your decisions face-to-face with your going to be ex-spouse. Next, we're going to talk about mediation. And mediation is also a form of alternative dispute resolution. This is obviously for a couple who's decided that they don't want to be married anymore. It's usually not financially complicated. And that couple is still able to sit at a table and communicate with each other, but they probably have some roadblocks or patterns that they need help getting beyond. So when you work with a mediator, it can traditionally, or is traditionally, one, maybe two professionals in the room who have been trained to help people come to their own decisions. They are not there. So say your mediator is an attorney. Your mediator can be an attorney, a financial professional, mental health professional. Say they are an attorney. Even though they're an attorney, they're not there, nor can they be there in a legal capacity. So they're not there to tell you what to do or give you advice. They're there as a neutral party to help you work through your disagreements and come to a conclusion where you get tripped up. So mediation can be good for people who have decided they don't want to be married, but they don't know exactly how to approach the process. They don't know what the steps are, and there might be some things that they have not been able to come to a resolution on, but with the help of a professional who is trained to help get through those roadblocks, they can come to an out-of-court resolution without involving attorneys in the direct negotiation process. And that's an important note. Divorce is a legal process. So depending on your state laws, and every state has different rules about divorce, You probably do need at least one, perhaps two legal professionals to finalize the divorce. And then our next process, our next and last, is pro se. We can call this kitchen table divorce, do-it-yourself divorce. Pro se is when a couple is going to basically make the decisions they need to make about their divorce themselves. And then depending on the laws and rules in your state, file it directly with the court or just engage a legal professional to file it. Many states, you can do this online. And the states are going to have the rules about whether you're able to accomplish this in your state. So that if this is a route you want to take, you first need to look up whether it's available in your state. And this is right for people, or probably a good choice for people where they've not been married a long time. They don't have children. They don't share assets, meaning it's not really complicated, but they still need to dissolve their marriage. And they still have to be able to communicate with each other. This is going to be the most expedient. So this is the fastest method if you can come to your own agreement. And it is likely the least expensive method. A note here is if there are things where you feel, well, I think we can work through this, but if you have a but, I don't know what my rights are, where we stand, then it might be a little more complicated and you might actually want to engage professionals to at least give you the information for any questions that you have. Next. Okay, so we talked about the different types of divorce, and you can always, mix and match in a way, have a little hybrid situation going on. If you don't have a collaborative, you can use a mediator with attorneys and kind of shape your own. So that's your first step. What is the right process for me and my family? The next step is to gather information. And what you need to know, and when talking about this before the webinar, this is information we all should have anyway, but we don't necessarily, whether you've been busy taking care of other things, life happens, or one party in the marriage has taken care of all the financial information. Maybe one has taken care of investments or the bills. If you don't have information as to your finances, your property, your assets, you want to gather that at the beginning of the process to the greatest degree that you can, because once you start in the process, depending on which direction it takes, you might not have access to it. So you're going to look at what you have. And by what you have, I mean just that. What do you own? And where is it? What are the account numbers? What are the balances? Who has access to it? Whose name is it in? All the things. And that's a space where working with a Cdfa, they can help walk you through what those things are, why you need them, what the nature of those accounts are. So you're understanding more fully what the rules around those accounts and dividing those accounts or properties might be. You want to look at what you spend. So this is kind of level setting, if you will. I know budget can often be considered a four-letter word, but this is essentially, what are your expenses? What is your budget? And typically people look at this as they live now. And when you're going through the divorce process, you're really looking at what it will be in the future and trying to estimate what taking one household and splitting it into two households look like. And that can be a really important part of discussing your settlement. Obviously, things are going to change when you take one household and split it into two. But it tends to be, in my opinion, a much better way of looking at settlements and things down the line if it's based in basically level setting reality. What does it cost in your city, if you're staying in your city, to have a house? If you have children, what are their expenses? And really getting a handle on that. And then who's going to take care of it? How will they be divided? And there are often things because one person has always, let's say, done the grocery shopping. The other person might not have really any idea what that really costs. So by figuring out what you spend as you're having these financial discussions, some of them difficult, you're able to look at kind of a reality-based need level to see that both parties are going to be taken care of, hopefully, and okay as they move forward. Again, this is an area that both a coach, but probably more a CDFA can help you look through and work through. And maybe because they have past experience doing this work with other couples, they can flag things like, oh, what about your homeowner's insurance? You know, whatever the thing might be, as they get to know you and your family, to make sure that you have as complete a picture of your budget as possible. Now,
before we move forward, can you just remind people what a CDFA is?
Oh, yes. A CDFA is a certified divorce financial analyst. So that is usually a financial professional. There are some attorneys as well who are CDFAs who have gone through a course of study. My book's right over there, about divorce finances, because they are different and they have different rules. So a financial advisor, whatever their specialty is, retirement planning, college planning, investments, and so on, may not have specific knowledge of the rules that are going to affect you in the divorce process for your finances. By using a certified divorce financial analyst, a CDFA, they're in tune with what the rules of divorce are, what may or may not be possible, because there are cases where even though a couple has come to an agreement, the agreement is not allowable. So they've first of all done all that work to come to an agreement, only to find that the laws of the state or the financial institution or of property say, no, you can't divide it that way, or that has ramifications on the other spouse moving forward. And the house is a good example of that. A CDFA knows the pros and cons and pitfalls of staying in a house and what you need to look forward if one of the couple wants to go purchase another house. Depending on how your settlement is structured, you may or may not be able to. So we're looking for things like that. That was a very long-winded answer to a CDFA is a professional trained in divorce finance. And just a side note to look out for, if you do have a financial advisor, that is wonderful, but there could potentially be a conflict of interest if your financial advisor is the financial advisor for a couple and then is working with just one while you're going through this process. So even if you have a financial advisor, and again, that's wonderful, everyone should have a financial advisor. Even if you have a financial advisor and intend to work with them post-divorce, you probably want to take a real serious look at whether they should be the person advising you or both of you during the divorce, both because of credentialing, do they have the background to do this very specific niche area? And is there a conflict of interest if they're only talking to one party, but they represent both parties? So just a sidebar caution.
Thank you so much. I figured people would probably need that information.
Yeah, and it's a tricky area. It really is. And it can be tricky for a financial advisor if they have a client, a couple who is divorcing. Giving advice to one or another is, again, tricky. So just something to keep in mind. And it just notes, you might not be able to get all this information until the process has started if you don't have access to it. And some examples of that could be if you are trying to get retirement plan information that is in your spouse's name, and you don't already have it, you can't call the company and say, hey, I would like a statement for that. It has to be provided through the account holder. So if you don't have that information, and I will circle back, I actually did this with a client yesterday, you can use financial records to find clues for whether those accounts exist. Looking at a tax return, looking at 1099s, it's kind of like scavenger hunt. So you can find it if you don't have access to it. Some cases you can't. And if you can't, but you suspect that there are financial assets you're not aware of, frequently one that comes up is if there is a business held by one spouse, there might be suspicion by the other that the business is being used to move money out of the family and into the business or keep money. We can actually look at those businesses and find a way to value it, find a way to see if personal expenses are being funneled through the business and so on. So again, other things that CDFAs, or there are business valuators who specialize in this. You can do property tracings and things like that. So get as much information as you can, but don't be dismayed if you don't have all of it, because as you go through the process with the proper team and professionals, they can help you get access to that information so that you're making good decisions. Another note on this is if you choose mediation or collaboration, you should be in a place where you believe that your spouse, both of you, are disclosing all the information that you have. So you have enough of a level of trust that you can put everything together and make your decisions based on that. If you don't have that level of trust, those are probably not the correct process for you, because there is no disclosure legally in those true process, the mediation or collaborative. So if you have a feeling that there's information being withheld, litigation is probably where you want to go, because then you go to the interrogatories and subpoenaing information and so on. So that is next step. So you have your process, you've gathered your information to the best of your ability. And keep in mind, some of these are going to overlap, but we looked at this as what is the right flow to consider as you move through this. So once you know the process you'd like to follow, then you can find the right professionals to support you in that process. So if you choose mediation, you want an expert mediator that you feel comfortable with. If you choose litigation, you want to be able to ask questions about how litigation works and whether it's the right match for you. I give my clients a questionnaire, how to interview professionals, that helps them think through, because divorce is such a case of you don't know what you don't know until you're in it, right? So it helps them think through, oh, if I'm looking for a divorce coach, these are some things perhaps I will ask. And I would think many, many professionals have that same type of checklist or questionnaire or guidance to how you find the right professionals for you. I would caution against finding your right professional because someone told you that they did just a bang up job on their divorce for whatever reason, without actually interviewing that person, that professional, and making sure that you are comfortable and feel like they have your back. So these are just some of the questions. How are you treated? Do they see you promptly? How do you feel in their office? Are you respected? Are you seen on time? Are you ignored? Do they answer your phone calls? Even if the answer is they're busy, they're in court and they can't get back to you for a week, it's still a response. If you get no response before you hired them, are you going to get a response when you're in the process? How do they bill? And this is something like real case scenario, real case example, actually. A couple getting divorced. One of the parties selected their attorney because they were the least expensive attorney. The other selected their attorney based on the rapport and support and information. At the end, and this was a more expensive divorce, the less expensive hourly attorney cost $49,000 to that party. And in this case, they were splitting the fees, so to both parties actually. And the more expensive hourly attorney was $35,000. So that's a really significant difference. You can't always judge based on the hourly fee or even the retainer how the workflow is going to be, because perhaps that more expensive attorney is more efficient in their work, or bills differently. Maybe they don't bill for phone calls. So asking about explicitly how they bill, what percent of an hour will, if you make a 5-minute phone call or send an email, is that going to cost 15 minutes worth of time, even though it was a 2-minute email read if they bill in the quarter hour, and so on. So you want to get more information beyond what's your hourly rate. How do they actually flow that through? Another thing to ask about billing is the frequency of the bill. I've seen cases where professional bills are held for months, and then the client gets a really expensive surprise because they haven't been tracking what that professional is billing, say in a 4-month period. So when they might have seen, oh my gosh, it's $5,000 a month, what is this for? And then be able to have those discussions about managing the cost of the divorce. If they don't get a bill for 4 months and then it's $25,000, you can't take that back. And bottom line, when you're working with professionals, this is a really important time in your life. Get people you feel comfortable with, follow your gut, check in. Make sure that you feel from the get-go like you're being supported and listened to. Okay, so that was overall professionals. These are types of professionals. So when you're looking to hire a divorce coach, you want to choose the type of divorce coach that fits your situation. They can be a mental health professional, attorney, financial professional. They actually might have another background as a divorce coach. And you can hire more than one type of coach. There might be someone, if you've been out of the home or at home, out of the workforce for a long time, you might want a coach who also does transition planning and helps you figure out, is my old career viable? If not, what does it look like? What do I want to do? There's a lot more transitioning frequently in the divorce process than just the marriage. So try to match that coach with your needs. What do we have next here? Okay, attorney, an attorney who is easy to communicate with, who knows your goals. And I think this one is very important. I would always look for an attorney who asks you what your goals are. What do you want your end result to look like? So that you're not just being plugged into what their process is, because you are a unique person. Your marriage was a unique relationship, and your life is very individual as to how you want it to look moving forward. The court system has its process, but your goals should be able to fit in and align with that. Would look for an attorney, and you can ask questions like this in your interview that doesn't supersede your wishes. So if you feel very strongly about something, and maybe it is, we're not going to battle over the children and use them as pawns. So if you feel very strongly over that, and you have an attorney who is saying, oh, we have leverage here, that's obviously not aligned. So look for someone who is listening to you, knows your goals, and doesn't bulldoze over those. I would encourage looking for a settlement-minded attorney. And you can ask these questions too, in the nature of, how often do you actually end up in court versus settling out of court? And do they have if they end up in court 50% of the time, but most cases are settled 95% of the time, there's a much higher likelihood of going actually to court. And then you have a judge or chancellor, magistrate, or jury making the decisions for you and your spouse and perhaps your family. And then I consider this a red flag. I understand why it happens, but if before they even speak to you, know your name, or know anything about you, you're handed a worksheet to fill out how much money you have or what your assets are, I would consider that a red flag. Your situation warrants support of professionals regardless of your balance sheet. And just as there are financial advisors who won't take anyone with less than $1 million in assets, There are attorneys who won't take anyone with less than fill in the blank, or look at that as a way of judging the value of your case. I understand that it happens, and it certainly can be important. And there are attorneys who specialize in high net worth divorces. But if that is the first thing that happens, I would take pause before having any kind of conversation. And our next one, oh, it's okay. I'm going to go back. We didn't have a CDFA slide, but, and then you don't need to go back with the slides, or you can. The same thing as a coach, there are different types of CDFAs, right? There are perhaps CPA, tax-based CDFAs. That might be the person that you want to use if there's a business involved and there's going to be business valuations, or you've had complicated tax situations. There are financial advisor CDFAs. And that's my background. If there are assets and investments that are part of the settlement, that might be the type of CDFA that you want to use. If there are more legal questions about how things might be divided, then you might want an attorney who is a CDFA. We can all get that credential and do the course of study. So you want to match that person to your needs. The same thing that comes from interviewing. You can also, if you're doing mediation, you can involve more than one mediator. You can have a mental health professional mediator or an attorney mediator who helps you do the parenting plan portion of your agreement. You can have a CDFA mediator who's a neutral, who helps you look at different settlement options that's informed, that are informed beyond just making a spreadsheet and dividing it down the middle. Okay. And it's okay to change your professionals. If you started with someone and you feel for whatever reason they don't have your back, you're not being listened to, you're being billed egregiously, it's okay to change your professionals and find one with the knowledge you now have that better suits your situation. And that is better than sticking with it and then, 5 years post-divorce going, oh my gosh, I wish I would have known, but I didn't because I didn't have a good relationship with my professional team or a professional on my team. Litigation process. So you've decided what the process is, and this seems repetitive, but it's important. You've decided what the process is. You've gotten your information together. You put your team together. But then you also want to know, how does it work? Like, okay, we got that far, but now we're actually in it. So what happens? In litigation, the attorneys are going to drive that process. They are the ones communicating for the most part, getting to the point where anything you need to reach agreement on, you've reached. In the litigation process, it might include subpoenas, depositions, interrogatories. Your timeline in litigation is going to be the timeline of the court. So if there are hearings, they will be scheduled when the court has time to get it on their calendar. If it's delayed, then it will leapfrog into the next time the court has time to get it on the calendar. So you really are merging the court process with your process, and you will follow what they have available. So one consideration might be finding out how busy your family law court, if you have a family law court, is, or finding how divorces in your area are handled. Is it that a judge comes through, and this actually in some outlying counties happens here, does a judge come through twice a month? In which case it might take a long time to get on the docket. Is there a dedicated court and you can get on the docket relatively quickly? Is the court so busy? And so on, you get the idea. With litigation, you don't know how long it's going to last. It depends on how long, it depends on the court calendar and how long it takes you to agree or be heard by the court. So it could be months, it could be years. With the collaborative process, it's usually the divorce coach who is kind of the business manager or the calendar or scheduler of the divorce. So they're managing the process and making sure that everyone in the process is kept informed about what we're doing, what the notes are, and what we're doing next. You have a team. Each party has an attorney, you have a divorce coach, and you have a financial professional, and you're meeting all together around the, I do this because I'm sitting at my table where we sit around the same table. You start off with goals. You don't start off with grievances or arguments. You start off each party with what you want life after this divorce to look like. And that becomes the metric that everyone is trying to get to. It doesn't necessarily mean everyone's going to get what they want. They probably won't. But it means that instead of winning, you have an end goal in mind for what you want life to look like. The number of meetings, team meetings, depends on the complexity and how much you have to handle, but that is scheduled out by the divorce coach, and that is part of an overall plan. When the agreement is reached, then the marriage settlement agreement or marriage dissolution agreement or whatever terminology is appropriate in your state is drafted, and then both parties sign it and it's filed in court. The process is legal, it's complete, and your divorce is final. And then mediation, which I believe is our next slide, is similar to that. Marcia, is that? Yep, mediation. So
sorry about that. Couldn't find the slide in time. There we go.
Button. So in the mediation process, and this is my process, but I think many mediators are similar, and it might be, if you're considering mediation, something you ask your mediator, like how actually do you proceed through this? So my process is an onboarding strategy session where you're talking about individual goals separately, and then you come together, and the goals of mediation, if you have children, are to put together a very detailed parenting plan so that you're not doing a look back, ideally in a few years, going, well, we never even brought up the subject of college, and now you've been divorced for 5 years and it's facing you. It's easier to do as much detail as you can with the information you have during the process. So you'll do a parenting plan, and then usually a few financial meetings depending on the complexity. Once an agreement is reached, then the mediator drafts what we call a Memorandum of Understanding, which is not a legal document, because even if the mediator is an attorney, they're not there in a legal capacity. That document is then given to an attorney or a legal document preparer. Some states allow that. And they write up the legal draft. And then the same as collaborative, the parties sign it, it's filed in court. Usually, and always qualify, it depends on your state. So frequently, this can be totally an out-of-court process where you're coming to your own agreement, and rather than attending court, a lawyer can represent you, or you can do it via phone. So you'll get on the phone. Look at how COVID has changed the process, but you'll get on the phone or a Zoom and attest that you have agreed to this, and it's final without ever appearing in court. Again, depending on your jurisdiction. And then pro se, you want to check out if you even qualify. Do they allow a pro se divorce in your state for your situation? And usually that situation is going to hinge on duration of marriage, whether you have children, and shared assets like a house. If you qualify, then you might be able to just find basically a DIY site, fill out the paperwork, file it online, and then wait until, depending on the rules of your state, wait until the time has elapsed and it can be final. You can also do it yourself and then engage a professional to look over the paperwork before you file. And in that, be careful, you want that professional to be a legal professional. Otherwise, if someone is looking at a document and giving you legal advice or representing that they can, that is actually practicing law without a license. So you want to stay away from that. And if you want someone to look over your document professionally, then that should be someone who is trained in the legal field. Okay. Oh, and now we're coming to a close. And this are just some things we think you want to be aware of. Again, you don't know until you're in it. Things to watch out for is an agreement to how you're going to spend your money during the process, especially if you're in separate households. This can cause the process to break down if there hasn't been an agreement or discussion about what happens, and then one spouse finds out the other spouse is taking trips or buying new clothes or spending out of character as a kind of I won't even go into the nature of that. Let's just say if someone is spending out of character, that can really derail the trust level, no matter what type of divorce you're pursuing. So if you can get an agreement as you're embarking on this process as to how you're handling the money and spending the money and stick to that agreement, it is much more likely you will have a better outcome. Sometimes people split up their finances during the process. They don't even wait until the end. I've worked with couples who start establishing separate accounts. You want to get to your advice of counsel as to, especially if you're litigating, whether that's okay. You don't want to do it unknowingly, because again, that can cause contention. If you're going to run out and start putting money in a separate account, not a good idea. But if you decide together that for whatever reason, it makes sense to do that and you do it knowingly, you can start that process as you're going through the process. Dissipation of marital funds kind of overlaps with the first. It's just something to look out for. And that dissipation of marital funds is actually something that can come back, and the spouse who was not spending the money can ask to be reimbursed for the money that was spent. So, and it doesn't have to be, oh, someone has a new person that they're dating and are spending money on that, although it frequently happens. It can be that they spent money on their rental apartment on an interior decorator and to furnish it. Well, the other spouse might say, well, you need to reimburse me for half that money because it was purchased with marital funds. So something to be aware of and look out for. Changing your name is just something to figure out if you decide that you want to change your name, when it makes the most sense in your process to do so. You can do it, but it costs more and takes more steps to do prior to divorce, or it can be done within the divorce paperwork. And then this is a really, really important one. I cannot emphasize enough because I've seen many mistakes happen when this isn't handled correctly. A quadro is a qualified domestic relations order. I'm sorry, that should be QRDO. I didn't catch that. Qualified domestic relations order. And in a quadro, that's taking any retirement plan, an ERISA plan, like a 401k, 457, 403b, taking those plans and dividing them. Each has its own set of rules. So you want to make sure, oh, look, on the fly, fixed it. You want to make sure if, as you're going through the settlement process, that you decide you're going to divide a retirement plan, that you can actually divide the retirement plan before the divorce is final, because otherwise you will end up back in court, or in some cases it can be a multi-million-dollar mistake because you might not have access to that. The plan sponsor might, and this is pensions as well, the plan sponsor might not honor it, and then you have no recourse. So again, if nothing else, write that down. Find out if you're doing a quadro as part of your process, whether it can be divided, because you want to make sure that your agreement can be executed and not get surprised down the road when you were counting on half a pension that you cannot get. And I think that wraps it up. So if we have questions, I'm happy to answer them.
Let me just come off of mute here. Yes, we do have some questions.
And I talked a lot, so I'm going to drink a drink.
All right, that's fine. So let me go ahead and pull up these questions here. All right, the question came in, collaborative and mediation feels very similar. Can you talk a little bit more about how those two differ?
I would say collaborative is more of a combination of the litigative process and the mediation process. So they're similar in that the couple is sitting together making their decisions. They're different in that in mediation, you're only working with a neutral. So whether it's a mental health professional, whether it's a financial professional, whether it's an attorney, they are not bringing their skill set to the mediation and saying, these are the legalities of your decision. They are in a neutral way walking you through the decisions you have to make. So they're not going to be giving advice. I would say, look at it as in litigation or collaborative, you have an advisor. In mediation, in the process itself, you do not have an advisor. You have a neutral party walking you through. So if you're amicable, that makes sense. And if you're relatively level on a power basis, that makes sense. Collaborative is the in-between, because you each have an attorney who is your advocate in the room, but you're in the room together and you're having the discussions about what you need to agree on face to face. And you're having them with the support of a financial advisor and a divorce coach. So I like to look at it this way. Like if you're, let's think of a project, you're renovating a house, right? You're not going to have the plumber do your wiring. And if you're renovating a house, you're not going to have the painter, think of it, hammer in the studs, frame the walls, right? You're going to use the professionals doing what they do. And they have different areas of expertise and they cost differently. And if you have the plumber framing up your walls are probably not going to be as sound. So think of collaborative like that, where you have a team of professionals who is helping you walk through this process and they're each doing what they do. So the financial professional is helping with the financial decisions, giving information. I use a software called Family Law Software. So we can look at the budget. We can look at how it affects people, how one settlement might affect people 20 years, 30 years down the road. So it brings a more holistic approach, which is a weird word to use for divorce, but it's a more holistic approach, I believe, to divorce. And it's not saying you can't use a CDFA in litigation. I support many people going through litigation, but it's a different process where you're mingling mediation with advisors. Does that answer the question?
Yeah, I think so. I think so. Okay, we got another question in here. Speaking about doing meetings like at a table or coming together, are people also doing virtual meetings?
Yes. Yeah, absolutely, more and more. Again, depending on your jurisdiction, whether the court is involved, they might be in person, they might still be virtual, they might be a mix. But certainly with my clients, I have out-of-state clients that I will do their entire process virtually. So yes, and it depends on the professional, whether they do that work. So it's, as you're interviewing people, another question to ask.
All right. This is a good question about quadros. And I'm not sure if I'm going to say this correctly to this participant who's asked this question. So if you need to clarify, go ahead and write that in the chat. If the plan does not honor one and the agreement states that funds are to be shared, how is that resolved? So does this recipient have a right to give that money another way other than litigation?
So I will disclaim, I am not an attorney, but as a financial advisor, I've seen this played out. It's not, you have an agreement, and that is your marriage settlement agreement, your dissolution of marriage agreement, whatever it's called in your jurisdiction. That includes your financial settlement. If the plan sponsor, after your settlement is final, says, no, we will not honor that settlement, then you have a contract that can't be enforced. So if you're amicable with your spouse, ex-spouse at that time, you may be able to go back and say, hey, the intent was that I would get, $37,000 a year for the rest of my life from this pension. And they say no. And the ex-spouse might say, okay, let's figure this out. In which case, even though they say, let's figure it out, and I'm going to honor the nature of the agreement, you still need to have a legal document drafted, because if in 2 years they say, yeah, I don't think so, I might have said that, but our document doesn't, or, you know, our legal agreement doesn't support it, you have no recourse. So think of that same line, from most to least aggressive. If you can come to an agreement and you have the financial means to fund what that was supposed to be in a different way, and then get it drafted and then get it filed, then you've basically addended your contract in a way that you now can execute. It is also very possible that if this is discovered later, and sometimes much later, that the courts won't even hear it, because, you know, maybe you discover 10 years later. And I've actually seen people not affect the quadro for many years because they think it's done. And that's why I'm so adamant about make sure it can be done before the settlement. But if it's after, it can range anything from, you might be able to work it out if you have the financial means to do so, or you might have no recourse, and then anything in between. But you are, if nothing else, you're stuck with a new legal and financial situation. So you want to have as complete an agreement in that settlement as you possibly can. And it's not hard to do. It might be time consuming. Just I'm so passionate about this because this can truly be millions and millions of dollars. It's not that time consuming. And for some reason, it's that thing like, oh, we get to the quadro later. To find out if you can have this agreement, it's just reaching out to the plan sponsor and getting an answer before the agreement is final. It might take a year. I've seen it take a year, year and a half to make the quadro in effect, because it moves at the speed of molasses. But at least you know that it can be executed.
And I'm assuming get documentation of that as well.
Yeah, documentation, all of it.
Yeah. Regarding that question, as far as figuring out how to contact the plan sponsor, and that's something that a financial advisor or a CDFA, someone like yourself, is very versed in doing.
Yes.
So that would be a process that someone like you could walk hand in hand with.
Yeah, at least starting to get the information. And then it's one of those things that, you know, you take the next step. So you might find out that you actually do need a lawyer to get the information, or at least write a letter to the company to prod them. And it might be as simple as, like, there are some companies that, and this is unusual, but they put their quadro on a one-piece sheet that you fill out. So it's asking the question. And once you ask the question of your HR department, or you're going to be X's HR department, how you affect a quadro, then you can find out what the rules are. And then you apply those rules to your agreement. And it can work the other way. There can be pension plans that say, if you are married, the marital part of this pension goes to your spouse no matter what. So that's working in reverse, where you might have said, no, you're keeping your pension. And then an ex down the road finds out that they have a legal right to a portion of it because the state says so, and you lose what you counted on. So it's asking the question about the plan as to whether it can be divided, whatever the nature of the plan is. And we're seeing more and more complicated things, like pensions are going away. So they're still out there and I deal with them, but less and less. But what we're seeing more of are restricted stock units, or bonuses, or shares of companies, the way an old ESOP would, but they're gifts. All sorts of alternative compensation that would be considered marital because it was earned during the marriage, but it might not be vested until post decree. So after the divorce, how do you handle that financially? So we see that and work through helping people figure out what portion is marital, how it can be divided, how it's going to be structured in their settlement, when they can count on receiving it, and so on and so on. So those are the cases where the more financially complicated cases, it really behooves you to have a CDFA who can help you figure out how these things look and how to value them.
All right, I just got another question and I want to go ahead and get this in right before we end here. How are inheritances handled in divorce?
That's a really good question. Again, attorneys and state laws are your friends, as is the Google, but inheritances are personal property. They are not marital property unless it's put into a joint account. And even then, there are some property tracing issues where you might be able to back out the inheritance part. But the simple form answer, and this is one where I would want to talk to this individual and know more details about it. But let's just say you are married and your great aunt passes away and leaves you $1 million. And you take that $1 million and you put it in your bank, in an account in your name. That is your $1 million. It's an inheritance. It is not a gift to the marriage. If you take that $1 million and you deposit it in your joint checking account, there is absolutely a case to be made that that is gift to the marriage. It's marital money. And now your million is $500,000. So, and the same goes for gifts. So if you receive a gift, you receive your aunt's jewelry in the same inheritance. That is personal property. Inheritance and gift are considered personal property. But that personal property can become a gift to the marriage if you, and it gets complicated, talk to a CDFA. But the other thing that comes into play is if you had separate property before the marriage, and if we have multiple marriages or people are getting married older, this is highly likely. So if you had separate property before the marriage and you keep it separate, it is your separate premarital property. It's not a marital asset. But if you take your 401k from before the marriage and you drain it and you use it for a down payment on the house that you're both titled on, it is now marital property. So these are the things that we look at, and depending on whether we're neutral or advocates, we're going to come up with either you should know this, like a reality check, or let's look at some ways to avoid this becoming a catastrophe, or let's look at how to protect your funds so that they are not being commingled.
Well,
That's a really super question, but it's a complicated one. That's one where you really want to get a professional's advice.
well, I really appreciate it. And I really appreciate the questions. And there were a couple more we weren't able to get to, but I would like to tell people, go ahead and leave your information in the chat. We'll go ahead and reach out after the event to make sure those get addressed. But unfortunately, our time is up. And I want to thank Brenda so much for being here and for the organizations that have made this webinar possible today. Thank you so much for our attendees for attending. Look to your email for a link to the replay of this event, and you're welcome to share that replay with your friends and family. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. Our matching service is free to you, and every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much for coming.
Thank you.
And we'll see you at another webinar very soon. Bye, everyone.